Welcome to iClass virtual channel. Thank you for being part of it. Today we are looking at buying and selling property, what every person must know. So we are looking here at the contract of sale. We are looking at what you should know regarding buying and selling property. So I hope that as you pay attention, you will find it both meaningful and informative for your purposes. We know very well that a contract of sale must conform to all the other requirements of a valid contract. In other words, it must satisfy all elements to do with consensus between the parties that are involved, issues of legality, issues of possibility of performance, and so on and so forth. But today we are looking just at a contract of sale. So we are looking at what is called the essentialia of a contract of sale. We are talking here about the essential elements that are necessary for us to decide or to determine that a certain contract falls within the class of what we call a contract of sale. So the essentialia or the essential elements are that one party, the seller, undertakes to deliver max, that is property being sold, to another party who is called the purchaser, in exchange for the payment by the purchaser of a certain amount of money in return for the delivery of the max. These are terms that help to determine the category to which the contract belongs, whether it is a contract of sale or another one such as a contract of lease. Essential elements of the contract cannot be varied by the parties, so it consists of parties to the contract. That is, the three elements that are necessary is the parties to the contract, the item being sold in purchased, which is called the max, as well as the pretium or the purchasing price. Now, these elements, that is the essentialia, have been confirmed in some of the cases like Munga versus the Minister of Rural and Development, case number 478 of 2011. That the case was concluded in 2014, and if you read paragraph 3 of that case, you get this summary of the essential elements of a contract of sale. We also have the Duplessis versus Goldco Motor and Cycle Supplies, concluded in 2009, and it also refers very extensively to this to the elements, that is the parties, that there must be parties, the parties being the seller and the purchaser, and then these parties to the contract must have an agreement regarding a max, that is the item which is being subject to the sale, and then the payment of the purchase price. So that constitutes the essentialia of the contract. If you look at that, we have a summary. Some two gentlemen there seem to be talking to one another and exchanging some stuff, which is money precisely, and the subject of the discussion or the exchange is that house in the middle, that property in the middle. Then on our extreme left we have a gentleman there who seems to have received large stacks of money. He's happy that he's received that money. So in other words, a contract of sale has taken place there. Still looking at the max, we are saying the max being sold, the max is the item being sold, and it must be definite and ascertainable. In other words, the parties who are discussing or negotiating a contract of sale must reach an agreement on exactly what is being sold, on what is being purchased. So we are saying the max must be definite. or if not expressed in definite terms, at least it must be stated in such a way that it can be ascertained using the formula that is given or using the description that is given. For instance, if it's a house or a fixed or immovable property, we might say it's stand number 218 at Mountainside View, suburb, held in terms of deed number BT 208/A1 at a town or a city called Skies. And then if it is a motor vehicle again, we may then tend to say it's a BMW XC series registration number ERC 111BL. So if you look at the descriptions there, they are quite clear and quite straightforward. You are able to tell exactly what vehicle it is or what immovable property it is that is subject to this contract of sale. Still on the same note, we've said that it is either certain or definite, or it's ascertainable. In other words, it's capable of being ascertained in light of the set criteria. For instance, somebody could say, I'm selling 200 kilograms of maize meal, or somebody might say they are selling 450 liters of liquid petroleum. So when somebody says they are selling 450 liters of liquid petroleum, you may look at that tank that we have there. The petroleum is inside. You may not have purchased or bought that whole tank that we have there shown in the picture, but certainly you are entitled to 450 liters. In other words, the seller may measure out 450 liters out of that big reservoir and deliver to the purchaser. So, and we have already said that the MECs can take the form of movable or immovable property, which are bought and sold in the market. And we are saying only res in commercio, or things that are amenable for acquisition and capable of constituting a person's patrimony or estate, are sold and purchased. And for instance, you can't sell and buy the sun or the moon or the stars. There are things that are capable of being purchased, those that are amenable for sale and exchange in the open market, and then there are those which are not. So we have what is called res in commercio, that is that which may be subject to commercial transactions, and then we have res extra commercio, which cannot constitute MECs or anybody's patrimony or estate. We've already given examples of the sun and the moon and the stars, or oxygen, the whole atmosphere. You can't, two people can't decide that they are going to sell and purchase oxygen or the whole atmosphere. You can purchase oxygen that is contained in what you call this, oxygen that can be contained in portable tanks, but not the whole atmosphere. Now, so still on that, you may find that sometimes you have to purchase, say, a whole head of cattle or some head of cattle. We are saying the price must be definite or ascertainable. So the MECs must be definite and ascertainable. Even the price must be definite and ascertainable. For instance, somebody might say, two parties might agree to the amount to be paid. They may also agree to the amount, or to the way the amount is going to be determined. That is, set a formula for determination of an amount. For instance, somebody could be, a Tabo is selling 100 Jersey cows to Tula, and Tula is buying them at 3,000 rands per cow. So in that case, we've been given a formula whereby you can multiply 3,000 by 100 to get the price for the mix. So we are saying if the price is not definite and certain, then it must be ascertainable by means of a pre-agreed or predetermined formula. Rights and duties of sellers is very, very important to understand them. We are saying the essentialia cannot be excluded by agreement, and we are saying naturalia automatically apply unless expressly excluded through the adoption of incidental terms. So we have spoken about the essentialia as the parties, the mix, and the purchase price. And then there are so many other natural consequences of a contract of sale. We are going to look at them, some of them such as the guarantee against eviction or warranty against latent defects, and so on and so forth. We are saying contracts are regulated by common law as well as statutory law provisions. So certain contracts have to be converted to written formats. For instance, the contracts dealing with the alienation of land or immovable property must be expressed, must be written. They have to, in order for them to be valid, they must meet those formal requirement. And then you find specific written terms may be varied in the contract in terms of maybe the introduction of incidental terms or whatever. And then the natural element of warranty against latent defects, for instance, can be varied to give a votes to sell, which means then under such circumstances would have varied the naturalia or the natural terms by introducing incidental terms or by varying them, so that instead of the seller giving a warranty against latent defects, you may say this item or this max is sold as it is, which means there's this word that expresses that is called footstool sales. So now let's look at the common law rights of the purchaser. It says that delivery of the max must always be free from disturbed possession, and the purchaser is entitled to the preservation of the max until it is delivered unto him. And then the seller's warranty against eviction must also be a very important element there. We are saying the purchaser's possession is not to be disturbed by a third party who claims to have a better title. It is the duty of the purchaser to defend possession against the third party, but when it comes now to the duties of the seller, where necessary, the seller must intercede or intervene in order to confirm that there is no third party who holds a better title against the seller. And then we also have got the implied warranty against latent defects, whereby we are saying the seller is liable for latent defects in the max unless the warranty has been expressly waived. We just spoke above about vootstoot sales, so that's what we were referring to when we were talking about sales that are undertaken on the basis of as is a condition. A claim based on latent defects must satisfy quite a number of elements or aspects. We are saying when somebody undertakes a claim against latent defects, he must prove that there's the existence of a material defect in the max that is rendering the max totally or partially useless. And we are saying that the max cannot be serviced to make it usable, and the defect must have been present at the time of the conclusion of the contract, and it must also be confirmed that the defect was latent. In other words, it could not be seen by the purchaser even during a diligent inspection. And it must also be proved that the purchaser was not aware of the defect at the conclusion of the sale. So these are the facts to prove when you are dealing with when you are having to prove a claim based on latent defects. or claiming that there's been a violation of the warranty against latent defects. Let's take note that fault is not a requirement. In other words, the purchaser doesn't have to claim or even prove that the seller was at fault or he acted in bad faith. So bad faith or malafide rather are not necessary. The purchaser doesn't have to prove any of that. It is sufficient for the purchaser to just show that all these other elements were present. Now, so what are the remedies in the event of, a violation or a breach of the warranty against latent defects? We have what are called deletion actions that are based on Roman law, where rights could only be enforced if a specific action existed in relation to the claims. So we have two types of deletion action. We have actio quantimoris as well as actio redhibitora. South Africa's law doesn't restrict itself to deletion actions. We have got other actions also, including another common law action called actio empty, but we will deal with that one a little bit later. In the meantime, let's look at actio redhibitora. We are saying if the defect is so material that a purchaser could not have purchased the max had he known about it. So in other words, the defect is so fundamental. It causes, maybe it makes it even, the item or the max becomes so useless partially or completely that holding on to the upholding this contract of sale would be to the detriment of the purchaser. So that purchaser may demand the return of the purchase price, or may demand an interest or repayment of the expenses incurred in connection with receiving and preserving the max, may even demand a reimbursement for improvements effected on the max. Maybe find that when the purchaser noticed that the max was not functioning properly, then maybe hired a serviceman to come and fix it. So he may have to make claims based on the expenses incurred in trying to service the max. So, but if the purchaser is going to demand a return of the price, the purchasing price, then he must also return the max to the seller together with any interest that may have accrued from the max itself. Now, so that's the first ideation action that we wanted to speak about. And then we also said there is the actio quantimoris. The actio quantimoris is the one again where there may be demand of the return price of the max if the max is so useless, so fundamentally defective that it cannot be of any use to the purchaser. Now, the other well, before we even go to the other ones, let's look at the deletion actions and how they were being used. They can be used for breach of contractual warranty, or where there has been concealment of defects, or there's been misrepresentation by the seller. You find that damages are not claimable in terms of actio redhibitora and actio quantimoris. We are going to look at how damages may be claimed since they cannot be claimed in terms of deletion actions. The remedies claimable in terms of actio empty include or rather they cover defective performance, misrepresentation, the manufacturer's warranty, as well as warranty against eviction. As we have said above, actual empty is a common law remedy deployed in order to redress defective action, where you find positive interest is claimable when max lacks qualities guaranteed by the seller, and the purchaser can also claim cancellation of the contract. Then in cases of misrepresentation, the purchaser can claim damages on the basis of negative interest. That is the position the purchaser would have been if the contract had not been concluded in the first place. So we call that negative action, in the sense that we assume the negative, that the contract had not taken place, so the purchaser didn't lose anything, and it is in a way punitive against the seller for the misrepresentation. We also have claims that are based on the breach of the manufacturer's warranty. For instance, experts and manufacturers may be held liable for defective performance in terms of the warranty. You find that a manufacturer, say, of a motor vehicle or motor vehicles, who then sells a motor vehicle whose braking system fails, and then it hits or causes other injury to other third parties, and then the purchaser ends up incurring liability. So that kind of a purchaser can then take the matter back to the manufacturer and claim damages on the basis of the breach of the manufacturer's warranty. And sometimes you say there's a breach of action if the seller fails to intercede against third parties who are making claims on the basis of a so-called better title than the purchaser. Right, we have looked at the common law rights of the purchaser above. Now it's time for us to look at the common law rights of the seller. And this is very simple and straightforward. The seller is entitled to payment of the purchase price at the time agreed and in the terms agreed. It's as simple as all that. So, and the payment must be in the form of money, banknotes, or whatever forms of methods of payment that they two have agreed upon. But it must be in money, and it must be at the time agreed between the parties. When property has been sold and purchased, the next item now is to think about how it is transferred from the seller to the purchaser. And we are saying transfer of property is an automatic consequence of the execution of the contract. Once property has been sold and purchased, it must be transferred from the seller to the buyer. Requirements for transfer include the following. There must be delivery. In other words, there are so many different modes of delivery. We have registration as one of them. We have delivery by the long hand, delivery by a short hand. We have constitution, what you call possessorium. There are many others. We will look at them on another video. And then we are saying delivery of immovable property is achieved through registration of deeds at the deeds office, and there must be an intention to pass a transfer or to transfer the property. The person transferring rights must have capacity to do so on the basis of the Roman principle of nemo plus juris rule, which stipulates that no person may transfer more rights than they hold. Then payment of the purchase price must be done in the terms agreed, and there must have been an obtaining of the security over the debt if the payment is not going to be immediate and upfront. A very important element of the law of contract is the passing of risk. When does risk pass from the seller to the purchaser in a contract of sale? Establishing the point at which the risk passes is essential for determining who between the seller and the buyer bears the loss in the event of a damage to the max. At a certain point, risk must pass from the seller to the purchaser. But at what point is that? We are saying it passes as soon as the contract is perfect, or as soon as the contract has reached the stage of perfecta. And when does that stage get to be reached? We will look at it a little later. But we are saying parties may agree on another risk arrangement. It's entirely up to them to waive or to alter the naturalia of the contract of sale by adopting maybe a different risk arrangement. And this can take place before formal passing of ownership is done. So we say a perfecta or perfection of the contract is a very essential element or feature. We are saying a contract becomes perfecta when max is definite or identified, when the purchase price has been ascertained and may be paid, and on the fulfillment of suspensive conditions, time clauses, or on the realization of a supposition. So the contract becomes perfecta. At that time, the risk then passes from the seller to the purchaser, provided that the seller is not, maybe you find at fault in terms of maybe negligence or through intentional damage. And we are saying that if the stage of perfection has been reached and then the purchaser is instructed or told by the seller, who then delivers or is ready to deliver the max, and it so happens that the purchaser is not ready to receive for some reason, and then the item or the max gets damaged. Sometimes you may find that the seller is absolved from any responsibility, so that the risk for damage now lies with the purchaser. So it is very important for us to look at all those different issues and circumstances. So far we have looked at the common law rights and protection of the contracting parties, particularly the purchasers. There are so many other statutory provisions and statutory enactments that deal with the protection of the rights of the sellers and the purchasers. We have the Alienation of Land Act 68 of 1991. We have the Sectional Title Schemes Management Act 8 of 2011. And then we also have got the Share Blocks Control Act of 59 of 1980, as well as the National Credit Act 34 of 2005. We are not going to pay attention to these today, but just take note that there are these statutory provisions. And then let's get to the end and the conclusion of our discussion. Just a recap. This presentation has highlighted the essential and the natural elements of a contract of sale, whereby we said there must be parties, then the max, then the purchase price or the premium. And we have outlined the common law and the statutory rights and duties of the seller and the purchaser in a contract of sale. And this presentation has identified remedies for latent defects. It has outlined the requirements for delivery of max to the purchaser and highlighted the main issues regarding the passing of risk. Thank you for being part of this presentation. Remember to subscribe and click the like.